get started, it's customary, we always have a prayer before our meeting. And at this time, I've asked Commissioner Dorsey if he would lead us in this prayer.
Let's pray. Precious Heavenly Father, we thank you for the opportunity to live in the United States of America, the greatest country on planet Earth. We thank you for the many freedoms that we have and the ability to govern ourselves. And we thank you for the many men and women, both past and present, who defend our freedoms, who fought for our freedoms, and who continue to defend our great country today. We ask that you keep them all out of harm's way, keep them safe, and see that they get back home to their families. We ask that you be with the many men and women in law enforcement, EMS, fire, first responders, and other branches of emergency services, and keep them safe as they work to protect us and to keep us safe. We ask that you give us all traveling mercies after tonight's meeting and the people's business has been completed, and ask that you keep everyone safe and allow them to get back to their homes and their families. And it's in your name we pray. Amen.
Amen. Can we all please stand and remove your hats and pledge allegiance to the flag? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. All right. I'd like to welcome each one here tonight. We appreciate each one that has come out tonight to as we proceed to take care of county business here. First order of business on the agenda is to approve the agenda. Do we have any additions?
Two additions. Under 13F, I'd like to add Willis Road subdivision for October Investments LLC and add litigation to the executive session along with personnel.
Make a motion we approve the agenda as amended. Second.
Okay, we got a motion by Commissioner Dorsey, a second by Commissioner Teasley. Any discussion? If not, let's call a vote. All in favor? 5-0. Next on the agenda is to approve the minutes of the previous meeting. Do we have any additions or corrections to those minutes? If not, could we get a motion to approve?
I make a motion that we approve the 3-9 regular meeting minutes. Second.
Okay, we got a motion by Commissioner Teasley and second by Commissioner Carter. Any discussion? Call to a vote. All in favor? It's 5-0 vote. Remarks by invited guests, committees, or authorities. No one here tonight. Reports by constitutional officers, department heads, county attorney.
Thank you, Mr. Chairman. I don't have any separate report tonight.
All right, thank you, sir. County administrator's report.
Just a couple of things. It's getting storm season again, so if folks haven't got signed up for the code red system, go to our website. It's on the left-hand side right there. You click it, it'll take you through and walk you through. You registering your cell phone to your address. Again, it's getting storm time again, so I advise everybody to be registered. If they're not, it's simple, easy steps. The road paving's picked back up again. They was working up in Bethany Bartlett area this evening. They should swing back through Deer Run and patch that pipe as they come back through going to Judd Cove. And I had something else wrote down. The prison crew. I did get a call from Whitworth last week telling us to get our vans ready. So we in hopes we're going to have the prison crews back in the next week or two. And my intentions are, as quick as we get them back, we're going to put everybody on picking up trash on the roads. We've got a contractor that's cutting the grass they was cutting. I'm going to let him continue to cut the grass and let them focus all their time on trying to get caught up on the road cleaning. That's all I have.
We just need to make sure before we start bush hogging, we've picked up these roads.
Correct.
Because if we get out here bush hogging and hadn't picked up this trash, it's going to be one big mess.
I agree with you.
So if you could make that happen.
Hey, Terrell, while you was up there on Ridge Road down there, like at the 4-way, where some cities dug up some water lines, and we talked about getting them to level that up.
Is that right there at the intersection?
Yeah, right there at the intersection.
Okay.
That's all I got.
That's all I have, sir.
Okay, thank you. We're just going to kind of skim through Chairman's report. I do not have any. District 1, do you have anything?
Not at this time.
District 2?
Move on.
District 4?
Nothing.
District 5?
No, I don't have anything.
Okay. All right, old business, amendment to beer and wine ordinance, to take this as a second reading.
Yeah, let me just put it on time. Gentlemen, I've not made any changes to the draft that was considered for the first reading, but I do have a comment to make. I know that one of the commissioners posed a question at the last meeting about the logic for limiting this to nonprofit entities. And basically, it correlates with what the city of Hartville did. Theirs is substantially the same. It's limited to bona fide nonprofit entities who may apply for a license not to exceed 2 days, not to exceed 4 times a year for festivals and things like that, other special events. In rethinking it, I don't know that I have as strong a feeling now about limiting it to nonprofits. I just want to let you know that. I mean, that's your discretion. And if you wanted it to broaden it somehow, one thing is, of course, that any entity in the county that would otherwise qualify under the beer and wine ordinance could apply for a yearly license. I think the purpose behind an events license is to give a group an opportunity to have a few days of licensed beer and wine sales without, going whole hog and having a yearly license. But because that question was raised by some members of the public, I just wanted to tell you, I think it's within your discretion to do it whichever way you want to do. I'll answer any questions if you have any.
Well, I kind of like the idea of a nonprofit because there's usually some kind of structure of governance. There's usually a charter involved, and they take a chance on losing all of that if they neglect some of the rules that have been placed there. So that's one of the reasons I'm strong for it.
Well, I fully understand that. My feeling is not one way or the other.
Right. Anybody else got any?
Yeah, I got an opinion on that. I was the one questioned at the last meeting, and I don't see the reasoning behind it. I've thought about it and thought about it and thought about it, and I can't justify it in my mind why we would limit it, because that'll limit the events you could draw into your county. And, just giving it to one group of people or a special group of people, in my mind, is just not right. I think all the taxpayers should have equal, fair, and impartial treatment. And if one can do something, the other should be allowed to do it also. To me, that's giving people preferential treatment. So I don't agree with that part of it. And I know that there's a lot of people out here. We got racetracks in the county. We got other groups in the county. We got people out here that could actually raise money for a worthy cause. But if they're not a nonprofit, they couldn't do it. And I think that's limiting. And really and truly, if you think about it, you're punishing people without due process, because if we got good qualifications on this and people are qualified and they're a taxpayer of this county and a business of this county, I think they should be allowed to do the same thing that a nonprofit could do. And I don't like judging people before they make a mistake. So you can't do this because you might screw up. I just don't like it, and I don't think it's right. And I could go on and on about that, but that's the gist of my opinion. And I got some other issues with it too. I don't like it, the 647C-1, the application not approved by the BOC, but the fee is. And it limits event to 2 weeks. 647C-2 again states the application is not approved by the BOC. It also says that county administrator shall investigate, and upon investigation shall present to the BOC for consideration, and the BOC shall be authorized to deny or issue permit. I'm kind of torn. I'm trying to figure out, okay, what are we going to be investigating? If we're going to be able to deny somebody, I would like to know what criteria I should use to be able to deny somebody. I don't like that person, so I'm going to deny him. I don't think it should be it. I think if we're going to have people doing this, they should have qualifications. If they meet the qualifications, they should be able to do it without being prejudged.
I think the purpose of that is your normal beer and wine license, you require a criminal background check. You want to know who's doing it and make sure there's not issues there. And that's where this language is coming from. I mean, ultimately, we're the ones that's going to have to make the decision.
Yeah, but what are we going to base that decision on? What requirements or qualifications will they meet?
Let me see if I can tackle that, Commissioner Carter, because I think you've made an excellent question. Number one, as to the due process argument, let me just respectfully state that the courts have historically ruled that alcohol permits are privilege licenses. They're not rights. No one has a right to an alcohol license. It is purely a privilege which you can grant as a board or you can take back as a board. And only the board can do that. The administrator doesn't do anything but investigate the same way that the clerk investigates the other licensees. And in this case, it'd be, are they really a nonprofit? Do they have a 501c3 tax exemption that proves them to be a nonprofit? Do they have some kind of corporate structure? Does that corporate structure have some type of government structure? Those are the kinds of things. And what do they want to do with it? You know, who's coming? How many people might come? You know, those are the kinds of things that the staff would investigate and then turn it over to y'all, and then you have absolute discretion as to whether to deny it or whether to grant it or deny it. And I really don't think there's necessarily a due process issue involved. If there is, the law has changed since I last read.
I understand where you're coming from, but the same point that I'm trying to make is this. If John over here could have an event, Joe over here should be able to have the same event, regardless whether they're nonprofit or not. That's where the due process argument comes in, because you're prejudging them people that they might screw up. But that's my opinion. That's what it's doing.
I guess I disagree. What you're doing is judging that it is either a nonprofit or it's not, and you don't have to have it there.
Well, I understand that, but that's what I'm debating the issue about. Why should we limit it to nonprofit?
What classes would you like to see it opened up to, since you brought it up?
Anybody that wants to have an event, if they meet the qualification and they can have an event, let them have an event. If they raising money for somebody that's sick and got cancer and they want to have some kind of special event, they should be allowed to do that.
That's generally going to be a nonprofit.
Huh?
That's generally going to be a nonprofit.
Well, not necessarily. That could be you. You got a friend that's got cancer and you want to have a special event, you should be able to have a special event. I believe in equal and fair treatment of everybody. I don't believe in allowing one person to do something that another person can't do. That's just me. That's the way I read it. What's fair for one, fair for all. There's an old saying, you say what's fair for the goose is fair for the gander. And I think we're limiting people thinking that maybe they'll screw it. And of course, if somebody does get a license and they go out here and screw it, then they can't get another.
Anybody else?
Well, I think we're here to stop problems before they start, so I'm with the nonprofit, and that way it limits things. And if somebody wants to start a nonprofit organization to have events to raise money for different people, then that's fine. They need to go out and jump through the hoops just like the nonprofits do to get into that. So I think it would be problems if we open this thing up to anybody that wants to come in here and throw a party. I just feel like we need to stop it before it starts, and I think it's a plus that we actually agree to let the nonprofits in.
There's got to be controls in place.
And them nonprofits have that. They do have that.
All right, any other comments? Can I get a motion to take this as a second reading of the,
So moved.
okay, we got a motion by Commissioner Dorsey. Do I have a second?
Second.
We got a second by Commissioner Teasley. Any other discussion?
Just one thing I do want to mention, and the reason I'm doing this as a second reading, one thing that we may want to consider before we adopt this from a third thing, reason for this is to move this on to a second reading. From a hospitality standpoint, we've got a lot of bed and breakfasts and things like that. Some other social groups that may want to do this that necessarily aren't nonprofits we may want to look at before we adopt this finally, that may want to have some kind of wine tasting or whatever the case may be, just as a thought. But if it's given away, you wouldn't have to have the license. You'd only have to have the special permits license if you're charging the sale. So that's the other thing to think about. That's one of the things that's been mentioned to me. So if they're giving it away, there's no need for this permit. But if you're selling it, then yes, there is a need for the permit. So just something to think about before we take the third and final.
Okay, thank you. Any other discussion? All right, we'll call for a vote. All in favor, raise your hand. All opposed? It's a 4-1 vote, Commissioner Carter. All right, next on the agenda, 12B, is amendment to Chapter 46, Land Development Standards, Article 5, Requirement Streets and Other Rights of Way. And I think Commissioner Dorsey had some suggestions in that area.
This goes back to some subdivisions that we've had some issues with, where we've got old roads that we either have prescriptive right-of-way or 30-foot right-of-way or whatever. Our current subdivision ordinance requires a 60-foot right-of-way. So some of these older farms are being bought, split up, subdivided, land that's been out there for a while on these older roads. And one of the things that this board is trying to do, we want to make sure we can provide emergency services and fire protection and EMS and that kind of thing. You get these roads that have 30-foot right-of-way, you get one fire truck in there, you're not going to get out. You're stuck because you're going to have volunteers coming and there's no room to park. Dead-end roads typically, it's just a big problem. So what we've proposed, and this is what we did at the last meeting, was we're going to ask, and this is something that, Walter, I'm going to ask you to put in the ordinance, and I'll make this an motion in a minute. I haven't had time to word it out the way we want to do it, but our target right-of-way is 60 foot, and that gets us in line with our current subdivision. What we're going to ask is that the developers, if it's less than 30 feet from the center of the road to the property line, that they deed to us the right-of-way so that it's 30 foot from the center of the road to the property line, and the width of the property they deed over to us for a right-of-way, we will in turn go back and grant a subdivision setback variance on the front for that amount of the property that's being deeded over to the right-of-way. So it's a wash. It's a win-win for both parties, and we've already set that precedent, but the responsibility to ask for the variance will be on the developer, because we want to make sure that we have these things clearly recorded in the minutes, so that 20 years from now, when somebody goes back and looks in the minutes, they can see why this decision was made. And that's standard with what we did. This also is there's a moratorium right now on these subdivisions with less than the inadequate right-of-way, as I'm going to call it. We enacted a 120-day moratorium to give us time to get an ordinance in place, but now we've got to get the ordinance updated, rather. We've come up with a solution. This is the way we're going, so I'm going to put this in the form of a motion to have the county attorney update the right-of-way so that we target a 30-foot width from the center of the road out to the property line of the property being subdivided, and in exchange for that, the developer can ask for a variance on the front setback requirements for the same width, and, we'll grant that. So I'll put that in form of a motion.
Okay.
Give me a second.
We got a motion by Commissioner Dorsey and a second by Commissioner Carter. We can't set a standard size of right-of-way because some of these right-of-ways are 40 foot, some of them's 30 foot, some of them, so I think that's the best way to put it, up to where we'll have 60 foot. So, any other discussion? All right, we'll call to a vote. All in favor? It's a 5-0 vote. All right, next on the agenda is the new business, local emergency operation plan, update, adoption.
Basically, the local emergency operation plan is something that we have in place, and basically what it does is outlines everybody's responsibility in the county for emergency support functions, such as law enforcement, missing persons, fire, whatever. And it has to be updated every 5 years. It's just a year for it to be updated. I put a copy of one in each one of y'all's boxes. I hope you've had time to look over it. Basically, the main thing that's changed is some of the state requirements on the command structure that everybody has to follow now with NIMS compliance. And personnel updated, who with what department, what agency, and whatever, and all their contact information. And it's by resolution the way it's adopted, and I don't think I got the resolution ready, but it's just a resolution stating you accept the local emergency operation plan as it is there. And again, this is to the public. They can have it. It'll be on our website. There's hard copies here. There's two versions of it. There's a public version and a private version. The only difference in the two versions, the public version does not have people's cell phone numbers in it. Otherwise, it's word for word the exact same.
Excuse me. I'll make a motion that we adopt the 2021 local emergency operation plan as presented by County Administrator.
I'll give you a second.
Okay, we got a motion by Commissioner Dorsey. We got a second by Commissioner Carter. Any discussion?
Yeah, this right here says record of changes. That's the only one change?
That's because it's a new version of it. If changes are made, that's when that's put in. In other words, we go back in and make an adjustment on personnel, it's noted the date that's made.
Well, that's what I said. It said record change. It said
Yeah.
one. But it said document completion. Is that?
Completion.
Okay, you might want to check that before you make it permanent.
And by the way, this is the first time in many, many years I didn't do this myself. And thankfully, I had Dan around, and he spent the last couple of months on doing this project. So, and again, I'll check we all make typos. Spell checks gets us sometimes.
Maybe dipping document competition.
No competition at all. He can have it all.
That's what I thought it said when I first looked at it.
But again, and I'd like to express my appreciation to Dan for getting it ready for me.
Yeah.
That was something else I didn't have to do.
Yeah, I agree with that.
All right, any other discussion? Call to a vote. All in favor? It's 5-0 vote. All right, next on the agenda is request for experienced sheriff's office.
I placed a letter in the packet from the sheriff. He has hired a certified deputy he's wishing to give 8 years experience, credit for experience. And again, this is just in the hourly rate. It has nothing to do with benefits whatsoever. And this is our standard policy.
This is consistent with our policy, so.
Correct.
Okay, we got a motion by Commissioner Carter and a second by Commissioner Teasley. Any discussion? If not, we'll call for a vote. All in favor? It's 5-0 vote. All right, next on the agenda, distilled spirits license application, Boathouse Grill, Jeff Adams.
All this in order.
Correct.
I make a motion that we approve this request.
Second.
Okay, we got a motion by Commissioner Teasley and a second by Commissioner Dorsey. Any discussion? We'll call to a vote. All in favor? It's 5-0 vote. All right, next on the agenda is City of Hartwell Annex request. We did get a application for annexation at 4:51 PM today. And we'll just start with the first one.
Mr. Chairman, could I just make a preliminary comment?
Yes, sir.
I do not believe, at least what has been delivered to me, if it is a complete set of documents, has a fatal flaw, all three. Now, it is an amendable defect, but it is fatal. And let me just say what I ground that on is Title 36-36-111, not 20, but 111. And let me just read this quickly. It's pretty short. Upon receipt of a petition for annexation, a municipal corporation shall notify the governing authority of the county in which the territory to be annexed is located by certified mail or statutory overnight delivery. Such notice shall include a copy of the annexation petition, which shall include the proposed zoning and land use for such area, and the municipal corporation shall take no final action on such annexation except as provided in this article. I've looked at this several times, and again, forgive me if I have overlooked something or not been furnished something, but what I have been what was delivered to me were 3 requests for rezoning amendments that were directed to the City of Hartwell, not petitions for annexation. I read the law very strictly, and when it says that the city will deliver by certified mail or statutory overnight delivery a notice including a copy of the annexation petition, I take that to mean an annexation petition. I don't mean to be overly picky about it, but the law is the law. And just as a preliminary matter, I don't think this one has been teed up right for y'all to strike at it at all, or for anybody else to. And my suggestion would be that that be considered, and that perhaps give the city an opportunity to correct the error.
The problem, Walter, is this is not the first time this has happened. This is the second time this year. We know there's things that's happened in the past where we haven't been duly notified. And, I mean, somebody at the city needs to be held accountable for failing to follow the law. Well, that's just my opinion. I don't know how everybody else feels about it, but so I'll make a motion that there's no action to take here. I mean, the city didn't properly notify us with an annexation application, and there's nothing for us to take any action on. So
Okay, we got
I'll make that as a motion. That way it'll be officially recorded. And I also request that the county attorney reach out to the city attorney, and let's make sure they get these things right going forward.
And let me also just point out that I did have a brief conversation with the city attorney late this afternoon. I think he's on the, as you know, he's why he ran for the legislature in the state of Georgia is beyond me, but he ran and he won. So he was on his way back from Atlanta when we talked. And I believe that he and I have an understanding that that the applications are flawed in that respect, and that they're going to wrap them up and bring them back to you. So they will be coming back. It's not going to go away. But we have also talked about how we might develop something kind of like what y'all did over the last round of unnoticed annexations. It was, and you remember, the county made a proposal for an agreement, then the city made a different proposal for agreement, and basically nothing ever went forward from that. I think there's a lot to be said for trying to get back together, maybe, in maybe a group of less than the whole, but if you want everybody to participate in it, that's fine. But I just think that there's something that could be considered and be agreed upon, so that while each one would be considered on a case-by-case basis, that at the bare minimum, that nothing would be considered or to be held to be precedential. But there are several things like that might need to be discussed, and I know that the city attorney is in favor of that type of approach, and I would have to say there's nothing to be lost by that, and perhaps plenty to be gained.
It's simple, follow the law.
Yeah.
I mean,
That's what it has to start with.
once they get the annexation application, they have 5 days to notify us.
Yes,
Then we have 30 days to respond back to them.
that's right.
It's very simple,
Very simple.
third grade level.
It's all right there in the law. Sometimes, I think, in all fairness to others, to everybody involved, the law is not always the clearest. Y'all know that. It's not always a model of crystal clarity. And in some cases, the law seems very clear, and then you look at some court cases where the Court of Appeals or the Georgia Supreme Court interpreted it, and they came at it in an entirely different way. You also, in this particular section of Georgia law on annexation, you've got different methods for the different methods of annexation. As we've talked before, there's the method of a 60% or a petition by 60% of the people, a petition by 100% of the people, on request of an applicant, which is what we have here, and when the state legislature determines that something should be annexed or de-annexed from the city. And all of those, it's not the simplest or clearest thing in the world trying to figure out just which standard applies to which method. But I just make that observation and say that I don't think that anybody necessarily has made any kind of deliberate mistake or any kind of misunderstandable mistake. To me, I understand when people, sometimes shoot without being loaded.
Okay, we got a
Mr. Chairman,
motion.
may I ask a quick question?
We got a motion by Commissioner Dorsey. Do I have a second? I give it, okay, we got a second by Commissioner Teasley. Now, any discussion?
My apologies, Mr. Chairman, if you'd like me to come.
If you come to the podium.
My name is Jay Dawes with Fuller Ranch Dickerson and Esco in Toccoa, and I represent the group interested that has requested the requested permission to annex the property. I just mainly want to make sure that I'm on the same page with the commission. By voting this in, y'all are agreeing to allow my clients to go back at the petition and resubmit it to the county, or to the city, and then to the county. Am I correct in understanding?
That's my understanding. I don't want to prejudge anything, but once the application is properly before the commission, then the commission will properly consider.
Okay. Because I'm in full agreement with Mr. Gordon. Even the statute says that the county and the city can agree to annex properties despite the limitations such as it being across the lake. And I agree fully that hopefully there's a way that we can work this out between the city and the county to where everybody comes out satisfied with the result.
Which group are you representing?
I'm representing Charlene Fields on behalf of the groups that are annexing the property. I can't remember the names. Doug Malk is one of them. Charlene, help me with the other names.
All the Lane Company, very big boat, and then the Hart Lane team on the front row there, should be turning.
Okay.
And how long have you been representing this group?
Since Friday.
Thank you.
Any other questions?
No, sir. No questions.
Okay, thank you.
All right, thank you. All right, we've got a motion by Commissioner Dorsey and a second by Commissioner Teasley. Any other discussion?
I want to say something. I had one of the parties contact me, and it was never disclosed that they were represented by an attorney. And I feel like that was highly unethical. And I just want to go on record stating that. I'm not going to name a party, but you call me and want to discuss something and you don't disclose that you're represented by an attorney, I have a big problem with that. Because if the county was involved, I would make sure that I told you I couldn't discuss it because there's attorneys involved, and that's the way it should work. So that's all I want to say.
All right. any other discussion? We'll call for a vote. All in favor? Any 5-0 vote? All right, we'll move on to Animal Control Ordinance Amendment.
Mr. Chairman, I have had conversations, and I put this on the agenda. I'm in the process of amending the county ordinance to include a lot of the state law requirements after discussing this with the sheriff and the magistrate judge. There's a lot of things that involve dogs, vicious dogs, dangerous dogs. We don't have those necessarily in our ordinance, and we'll be bringing back for the next meeting for first reading an updated county ordinance to talk about the dog issues with input from law enforcement and the problems that they deal with. They don't have access when they're out on the scene to state law, so they rely on our county ordinance, which they can have a hard copy with. So there's a lot of things involved that we purposely, and I'll be the first to say it was a mistake when we did it. We tried to keep the ordinance as crisp and clean as we could, but assuming that the state law stuff would be readily accessible. But this is a welcome change. I talked to the sheriff today and the judge, and they feel like this is a step in the right direction. So just wanted to let you guys know what the plan was, and we'll go from there. There's no need to take any action tonight.
Okay. Thank you, Commissioner Dorsey. Next on the agenda is Willis Road subdivision.
This subdivision is located up on Willis Road, just as you turn off of, can't remember the name of that road you turn off Willis Road on, but it's up in the...
Walker.
Yeah, you turn off Willis Road on the Walters Way. This is on Walters Way. And I think they have, on the right-of-way issue, I think they have made the adjustments in the plat. Because I pulled several of the plats from this point down. One plat will show a 40-foot right-of-way, the other plat shows no right-of-way. So I don't know how to come up with the exact, what our existing right-of-way is on the road anyway. But this should take care of it. We were talking about amending the ordinance a while ago. This should take care of our concerns at that point. Everything else is in order. The health department has brought me stamped copies from them. I'm not aware of any other issues with it.
So can we get a motion to approve with the conditions of our moratorium?
Does it show the setbacks? I'm just...
It's listed on one of the notes. Yeah, it's adjusted to 25-foot setbacks, so it'll be 15 foot off or 40.
It shouldn't be 15. It should be 10, based off what we're trying to do. Because you got 40-foot right-of-way now. 20 foot from the center of the road to the property line, we want to get to 30, so it should be 10.
It's 25 feet from the right-of-way to 60.
Yeah, like I say, looking at different plats down this road, I don't find a consistent plat that shows the same right-of-way over twice.
But what I'm saying, we want to be from the center of the road over to the property line at least 30 feet. And then we'll give the setback from 40 feet back to 30.
If you look, if you zoom in close, he figured a 30-foot right-of-way on the road. Am I correct?
30 feet from the center each way.
But again, your original road was a 30-foot right-of-way.
That's correct.
I thought you said it was 40 foot.
No, I'm saying, me looking at plats going down this road, you'll see one that's showing a 40-foot right-of-way, the next one not showing any right-of-way at all. So I assume the prescriptive right-of-way applies here, which would be 30 foot. So he measured, could take it into consideration a 30-foot right-of-way on the road, existing road, and pull 30 foot from the center line off. which would have been,
So he's adding 15 feet to the right of way, so in all,
It's taking it back.
25 foot.
correct, and then we're knocking the 15 foot off on the other side of his property, which is setback.
I'll make a motion that we approve this in
I'll give you
in the concept of our moratorium solution, but they will need to be a deed drafted up, signed to deed that property over to the county, because it will become deeded right away.
I got some real something.
And we'll grant the variance on the front distance setback.
Okay, we got a motion by Commissioner Dorsey. Do I have a second?
I'll give him a second.
Okay, we got a second by Commissioner Carter. Any other discussion?
Just so you be clear and understand, this is on Livonia, City of Livonia's water, so
There is water.
there's public water there.
Okay, no discussion. We call for a vote. All in favor? It's a 5-0 vote. Next on the agenda is the public comment. I don't know,
Public comment.
Public comment. Would anyone like to address the board at this time? And if you would, come to the podium and speak. Public comment? If not, can we get a motion to adjourn and go into executive session?
I'll make a motion, we go into executive session for litigation and personnel.
Okay, we got a motion by Commissioner Dorsey and a second by Commissioner Bennett. All in favor? It's a 5-0 vote.
Executive session, back in the regular meeting.
We got a motion by Commissioner Dorsey, second by Commissioner Teasley. All in favor? 5-0.
Make a motion, we adjourn.
Wait a minute.
Oh, we got,
Whoa.
that's right, jump the gun there. I'll make a motion that we create a full-time animal control position and take our current part-time position and make it full-time. That's how we'll accomplish that.
Second. Okay. We got a second. We got a motion by Commissioner Dorsey, second by Commissioner Teasley. Any discussion? All in favor? Raise your right hand. So it's 5-0 vote.
And training got canceled, right?
We could have made it, kid.
Yeah, we could have. That's why.
Is that clock right?
Yeah,
Huh?
You put it up there, you ought to know.
It ain't even moving.
that's right.
That's right.
I'll make a motion, we adjourn. Second. All in favor?
All right.